I've given print of that 1956 PL plan.
कहाँ है? Yes, what do you have to say in response?
Yes. Regarding arguments with regard to the first substantial question of all,
Yes.
Learned has submitted that these judgments which are relied upon is with regard to settlement.
Settlement or hukumna,
So
where the person was claiming title.
claim. Now here perhaps what I was relying upon is in this perhaps 2014 ACC online Patna, Para 5.
Is it binding on us?
There is another judgment of this honorable court, Ranchi bench, 87 Justice S.B. Sanyal judgment. That's wherein it has been observed, held, that the nature of land changes with passage of time with its user. I will give the judgment. Para 5 is with regard to entries made in record of life.
Let us see the foundational facts of this case. You are relying upon this judgment heavily?
Yes, 2014, SCC online, Patna 7.
That's right. Kindly place the facts.
Counter affidavit by the state and rejoinder by the petitioners have been filed. Concern of the parties with petition has been heard for disposal at this stage. Petitioners are resident of Bariapur district of Mumbai. They apprehended that not only the eviction from the lands which they are occupying for 5 to 6 decades, but denial of compensation as well. In this petition, they have asserted, and which is not denied by the state, that they are in possession of the land and decided thereon for over 5 decades. The road overbridge across the railway line is too long. State has sought to acquire the lands for sale. Land acquisition proceedings were initiated in respect of certain lands. Lands were acquired at 100% compensation paid, but for part of land which is also intended to be utilized for the said bridge, instead of acquiring them upon payment of compensation, inquiries have been started with regard to correctness or validity of the Javabandi in favor of those persons. It is averred that this is just solely for the purpose of forceful evicting the petitioners from the lands and their house by cancelling Javabandi and denying them compensation. In other words, what is submitted is that only to avoid payment of compensation, state is taking steps to cancel long-standing Javabandi, whereafter they would be evicted without any compensation. State filed a counter affidavit. State does not deny that for part of that acquisition proceedings were contemplated and compensation paid, but in relation to the petitioners, state admit that though the petitioners have been in possession for decades, it seems that the settlements were wrongly made in their favor. Stand of the state is that when records were being examined, it was found that these land in the cadastral survey which were carried out for more than a century were shown as either Gair Mazur Aam, Gair Mazur Khas, or at places Kaisari. Therefore, according to the state, prima facie settlements would not have been made. Further inquiry revealed that Javabandis which have been created several decades back do not appear to be authentic or correct. State reverts the contention of the petitioners that they would summarily evicted and denied compensation. State submits that they would act in accordance with law and have initiated a proceeding for cancellation of Javabandi, whereafter Javabandis being cancelled, they would be evicted. In such a situation, state admits that they may not be liable to compensate it. In rejoinder to the counter affidavit, petitioners reassert their contention that they have in possession, which position stands undisputed. It is now a matter of record that proceeding for cancellation of Javabandi to denial of compensation while acquiring land is admitted. They submit wherever there is a conflict of private and public interest, petitioners are ready and willing to give up their land, but for public good, provided proceedings are duly initiated, they are compensated and rehabilitated as per the right to fair.
You see, you just see para number 8.
And
It says that para 8 of this judgment. It says that the state can go for the title suit, get a declaration, and everything will be subject to that declaration.
no, what para 5 is it?
You see, in the case of land acquisition, the law works in a very different context. Even persons who are in occupation of the land, they are paid compensation. It's not that only your title has to be.
No, my submission
So it's a proceeding under Land Acquisition Act. You just read para 8, last 4 lines.
The
If they
result of
intended
this-
to cancel the Jamabandi, you read it, para 8.
The result of these 3 progressive stages is that if the state wants petitioner's land or land on which the petitioners have been residing for 50 years, they must pay due compensation and take action according to the provision of the new land acquisition act. If they intend to cancel Jamabandi, it is for them to move the civil court for declaration. Yes, that is the law.
That is the
But again, this is also when it's
So, you see, there is a huge caveat to this.
here. Now the state has also in this suit. State is a party. State has not adduced any evidence. But
That's right,
It is merely
Steve,
there.
but it is your case that you were found in forcible illegal possession.
Yes.
That's
Now
your
that-
case. It is not
that-
your case that you were put in possession by the landlord and then you continued in
But I
possession.
came
That
in
is not
possession.
your case.
Not my case.
Yes.
But the landlord, before vesting, did not initiate any
That is
proceeding.
a separate thing. We do
So
not
therefore,
talk
by
about that.
prescription, by adverse, by efflux of time, my predecessor in title acquired right by adverse possession. And secondly, though it is recorded as sarna, minus the defendant witnesses have admitted it was never used for sarna purpose.
Never means what?
Never.
Never means what? Since 29. What personal knowledge do they have? Since 29 it was never used as sarna. You make a statement that it was never used as sarna.
That is what is recorded. That has been recorded, and the defendant witnesses themselves said. ये कभी
Kabhi matlab kya? Kabhi means what? Defendant witnesses were not even born at that point of time to make a statement that it was never used as sarna. The fact that it is recorded as sarna has got great value. It is not your case that it was wrongly recorded as sarna.
not my case.
It was never your case.
Yes. My case is, though it was recorded as sarna, at least since 1929 it was not used for that purpose.
Because you were
I
occupying
was
it.
in possession.
Forceful possession.
Forceful possession, but I continue to remain so.
That's so you are claiming adverse possession.
Yes, it was.
Got it.
And secondly, one is with regard to the judgment cited by the learned friend that I cannot maintain a suit for on basis of title and adverse possession simultaneously. Here, one is I have gone through this judgment and respectfully, one is like I must say that the Supreme Court knowledge does not say, and specifically say para 8.
Which judgment you cited that list?
Yes,
2022.
2022 volume 10.
Yes.
Now, what had happened there was proceeding. The title of the plaintiff
Was not on basis of sale deed was not accepted, and also on point of adverse possession it was not accepted, but still injunction was granted. Under that circumstances, the Honorable Supreme Court says that in view of the matter, one substantial portion of law of adverse possession has been held in favor of appellant original defendant number 1. Title ownership claim on basis of sale deed dated such and such was negated by all courts. Thereafter, alleged possession of the premises could not have been protected by passing a decree of permanent injunction.
Which paragraph did you read?
But it's-
How do you distinguish this?
Yes, it does not say that I cannot maintain a suit for title and for declaration on basis of title and adverse possession.
Very much says so. How do you say?
Minus the tense. I'll just read the
Paragraph
result paragraph.
7. You read paragraph 7.
Now, this is what the High Court holds.
Having gone through the impugned judgment and order passed by the High Court as well as the First Appellate Court and even that of the learned trial court, it appears the original plaintiff played for a declaration and claim title ownership on basis of sale deed dated such and such. Simultaneously, plaintiff also claimed by title by adverse possession. All the courts below have negated the claim of the original plaintiffs of ownership on basis of registered sale deed dated such and such. Therefore, the only claim on behalf of plaintiff was plea of adverse possession. So far as plea of adverse possession is concerned, the High Court has specifically framed substantial question of law, and as such held the same in favor of appellant original defendant number 1. The High Court specifically observed and held that plea of ownership based on sale deed and adverse possession both are contrary to each other, and the plaintiffs cannot be permitted to take both the pleas at the same time. Thereafter, even as per High Court, the claim of plaintiff on basis of adverse possession was not tenable. In view of the matter, once a substantial question of law on adverse possession was held in favor of appellant defendant number 1, and the title ownership claim on basis of sale deed dated 31/8/67 was negated by all courts below. Thereafter, alleged possession of the plaintiffs could not have been protected by passing a decree of permanent injunction in favor of the plaintiffs. Under the circumstances, the High Court has materially erred in dismissing the appeal and confirming the judgment passed by the appellate. Now, the judgment which I had cited, Ravindra Kaur Grewal judgment, para 11 of that judgment. At page 745. In Kritish Chandra Bose versus Commissioner of Ranchi.
See, we will not read a judgment from a judgment as quoted in a judgment. Whenever we read a judgment, we read the judgment itself. This is not the way of placing a judgment.
Here, I wanted to demonstrate that the plea was based on a hukumnama as well as adverse possession. Both were
Your own case is that you were under forceful possession.
Yes.
When did it become adverse? Not from the date of forceful possession. When did it become adverse?
as against the Zamindar one itself.
When? What is the starting point? How do we calculate 12 years?
So entry in record of rights is illegal forceful possession.
Forceful. So on the date of entry, it was forceful. That is in the year 1935, whatever you are saying.
32 was
32
final
of-
publication. Final publication.
On that day, it was forceful. So it cannot be said to be adverse on that particular day. So on which day, where is the foundation pleading that subsequently it became adverse on and from such and such date? That is required to be pleaded. There is no such pleading to that effect.
Para 13, 14, 15
No,
specifically-
because it is not your case that you just came in possession of the property or was handed over that property or you were in permissive possession also. Even that is not your case.
The case is based on entry in record of rights. I admit.
Entry itself is forceful
Is
possession.
forceful entry.
So as long as the entry is forceful, it means that somebody is objecting to it.
Yes.
When was this cloud of objection vanish? When did you acquire a right of adverse possession? These are foundational pleading which is required for an adverse possession. That is absolutely missing in your plate.
In my response submission, it means sufficient pleading. There is sufficient pleading in the plate with regard to adverse
You
possession.
can't concede, I appreciate that. But the point is, you appreciate it as a lawyer. Once your entry is said to be forceful, right? You cannot be said to be in adverse possession from 29 by any stretch of mind. Even on the date of entry, you cannot claim adverse possession because it is entering as forceful possession. Somebody was objecting. That is why it is forceful possession. Okay. So thereafter, how does it become adverse to the real owner of the property? From which date? When did you acquire the right of adverse possession? These are very foundational facts to lay a claim of adverse possession. That is why the learned trial court did not even frame an issue on adverse possession. The appellate court also did not frame an issue on adverse possession. There was no occasion.
But there is a fact.
And while framing the question of law, the exact term was not there. Sadhana was missing, maybe that it was not in italics, that is why that was missed out. Right? Because rest of the portion was in bold and italics, so it was very much apparent. But the entire entry was not mentioned in by framing the question of law. And by framing the second question of law, it was also not maybe that not pointed out that the plea of adverse possession was rejected on two grounds. Not only that what has been framed, but also that you cannot claim title as well as adverse possession simultaneously. There were two grounds for rejecting that plea.
The appellate court only says that it can be used, it cannot be used as
No, both the points are there in the appellate court's judgment.
I'll just please. Para 17.
Para 16. Para 16 of the title suit.
Yes, in title suit there is this observation, but in
Yes.
appellate court refuses to examine it.
That's right.
Appellate court says that it can only be used as a shield, not as a sword.
But this is absolutely untouched, this one, para 16. Isn't it? Anyways, this is the best you could have done. We'll pass the judgment. Certain. Anything else you want to say?
But one more thing, I thought it was can I just refer to one paragraph of this Ravindra Kaur Grewal?
Yes, please.
Para 61.
16.
Adverse possession is heritable and there can be typing of adverse possession by two or more persons as the right is transferable. So this
Yes,
matter
yes. This
Now
law
my
is
case is,
exactly now.
yes, my case is that my predecessor in title, whereas by remaining continuous possession, acquired title by way of adverse possession, and thereafter, well, they sold the land to my vendor, and thereafter it came to me. So my plea of title on basis of a document and adverse possession is not contrary to each other. It is not inconsistent with each other.
The learned counsel for the appellant in response has referred to the judgment passed by the Honorable Supreme Court in the case of Ravindra Singh for Grewal Supra and has referred to paragraph 61 of the said judgment to submit that adverse possession is heritable and there can be tacking of adverse possession by two or more persons as the right is transmissible one. He cites that the predecessor in interest of the appellant had acquired the right by way of adverse possession of the property involved in this case, and therefore the subsequent sale deeds were also essentially based on the claim of adverse possession. He submits that the right to continue in possession by way of adverse possession acquired by predecessor in interest of the appellant devolved upon the appellant, though by virtue of sale deeds. He submits that therefore under the facts and circumstances of this case, the plea of adverse possession and the claim through title are not inconsistent with each other and therefore both can be claimed. The learned counsel has relied upon the judgment passed by, has referred to the judgment passed by the Honorable Supreme Court of Honorable Patna High Court, reported in 2014 SSC Online Patna 7936 within bracket Maya Devi versus State of Bihar, and has submitted that this judgment has been referred to in the first substantial question of law, and it has been clearly held therein that an entry in cadastral survey, which was over 100 years old in the said case regarding the nature of land, was not an entry for all times in future. We have submitted that though at the relevant point of time the property involved in this case showed the entry as कौन सा land?
गैर मंजूर हुआ आम लैंड
नहीं
सरना
Sir,
क्या
सरना
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 हाँ.
सरना
Sarna land, but with the passage of time, admittedly, admittedly the same was not utilized by the public as Sarna land, as the same remained in possession of the appellant. He submits that with the passage of time, the nature of land has changed and it cannot be said to be Sarna land anymore. That's all. Arguments concluded.
can I just pass on one or two the 81 judgment which has been referred?
I will see it. Don't worry. इसको बिना देखे हम ऑर्डर नहीं करेंगे.
Print out अभी दे
दे तो अच्छा है. टाइम मिलेगा तो दिखा देंगे ना, तो लंबा दूँगी। कौन स्टेनोग्राफर? आप ही?
Orders with effect item 7. First appeal 159 of 2018.
आप बताइए क्या डिफेक्ट है इसमें?
As per the office note, madam, some defects are showing, but that has been removed. Madam. The CC is not there, but CC is filed in the CMP. Madam. CC of the judgment has been filed with the CMP. Madam.
You have removed the defects.
Already.
Defect number 2, CC of
That has been filed along with the CMP. Madam.
judgment passed in the CMP.
Madam. As per the direction of the honorable court, madam, that has been filed with the CMP.
कहाँ है CMP दिखाइए?
CMP is a part.
उसके साथ ऑथेंटिकेशन फी भी डाल दिए हैं। Value of appeal,
That is also correct, madam. Actually, we are claiming at the rate of 8,000 rupees per decimal, and already we have received 3,000 rupees per decimal. So the balance amount which we are claiming at the rate of 5,000.
so trial court में कितना था? अच्छा ये तो first
Trial court we have
Okay.
asked for 15,000 per decimal, but as the in other villages only 8,000 rupees has been awarded. So
Now you are claiming only 8,000.
only 8,000 because in several villages only 8,000 is maximum 8,000.
देखिए first appeal number 152 of 2018. Learned counsel for the parties are present. The learned counsel for the appellant submits that the memo of appeal, that the judgment and decree also.
Decree was already filed. Well, decree, the award is there. Award has already been instead original copy has been filed
The
along with the
judgment,
first appeal. Separate award in each case.
the judgment,
पहले ना 5 cases.
the impugned judgment with authentication fee of rupees 10 has already been filed in CMP number 782 of 2024, which was a petition seeking to restore the first appeal. Peruse the records of CMP. The judgment with authentication fee has been filed in the said case by supplementary affidavit dated 18/12/2024. The office is directed to replace the judgment filed. The office is directed to consider the judgment filed in CMP
CMP number
number
782.
782 of 2024 as having been filed in the present case. Accordingly, the defect number 1 is hereby ignored for the present. So far as defect number defect number 1 is, this defect is ignored for the present. So far as the defect in connection with valuation of appeal is concerned,
That is
the
rightly-
counsel
rightly-
for the appellant has submitted that initially the appellants were claiming land at the rate of
15,000 per decimal.
rupees 15,000 per decimal, but in the appellate court they are claiming it at the rate of rupees 8,000 per decimal. He submits that such plea has been taken, such plea is on the basis of the compensation given in
Several
adjoining lands.
Yeah, ordinary villages.
He submits that accordingly the appeal has been valued. Considering the submissions, the objection in connection with valuation of the appeal is also ignored for the present. याद रखिएगा ये चीज़, अब फाइनल बहस का समय 15,000 का बहस नहीं होना चाहिए। उन्होंने अपने लिए बोले हैं कि 8,000 क्लेम कर, ठीक है ना? बताइए क्या करना है?
My lord, one more thing is there, my lord, after the calculation of the court fees, I may be permitted to deposit the court fees, that is after calculation, second calculation. For that, time may be given, my lord. Because
Office
there
is directed to carry on further stamp reporting in view of this order and post on
other
next
cases are
Wednesday in the supplementary contest. बताइए और भी कोई related cases है
one more
क्या?
cases, then after that, item number 8, my lord.
इसके और भी related matters हैं?
No.
नहीं है ना? ठीक है। नहीं, same
Different is my lord, substitution petition IA is filed, so may kindly be substituted, my lord.
किसको substitute करना है?
These are the legal heirs and
Of
Rameshwar Baby.
Rameshwar, the appellant.
Now this is
Now this is means when did it die?
after prior to after filing of the application.
कहाँ लिखे हैं?
For that purpose, IA has been filed, madam, 4448.
बहुत सारा आइडिया है इसमें।
IA for liquidation is also there. There is a delay of 26 days, which has been condoned,
एक
madam. For
CMP
that
भी
purpose,
फाइल हुआ है। CMP क्या चीज़ के लिए फाइल?
CMP for restoration that has been restored there after this case. Appeal has been restored.
तो इसमें क्यों लगा हुआ है CMP?
That is part of the original record.
ये है 4476। 4476 हमको दिख रहा है। केस नंबर ठीक से देख के बताइए। आइए नंबर 4476 आप कौन से सब्स्टिट्यूशन पिटीशन की फाइल कर रहे हैं?
That is that for application for substitution of legal representative under order Rameshwar Baby.
तो इसका नंबर है 4476। और कौन सा आई है?
Triple 48. Yeah, it is
ट्रिपल
there.
फोर एट क्या चीज़ के लिए?
For addition of two IR there. There are two
आइए
IR.
नंबर भी नहीं ठीक से देखेंगे तब
नहीं,
तो
नहीं,
भगवान ही
there are two
आपका
IR.
मदद कर सकते हैं, कोई और नहीं सकेगा।
There are two IR, my lord. One is 4476 and 4448. 4448. The appellant number 1, Rameshwar Vedia, died on 16/9/2021, leaving behind Shamru Vedia as his Rameshwar Vedia and Mukesh Vedia as his legal representative and Chakki Devi as widow. And another appellant number 4, Chamru Vedia, also died on 13/5/2022, leaving behind his two sons, Kanchan Vedia and Kulchan Vedia. And in second IA, madam, awardee number 3, namely Biglaha Vedia, that leaving behind two sons, W Vedia and Sikandar Vedia. So two IA are.
आप तो दोनों अपीलेंट की तरफ से फाइल कर रहे हैं
जी।
ना? तो डेथ सर्टिफिकेट क्यों नहीं फाइल करिएगा?
Because they are not having the death certificate.
What do you mean? कहाँ लिखे हैं कि you are not having the death certificate? और कौन नहीं आपको डेथ सर्टिफिकेट दे रहा?
Village they
विलेज में नहीं मिलता है।
मुश्किल होता है, उनको टाउन जाना पड़ेगा, वहाँ से लाना पड़ेगा। We are giving the dates. उनको मिलता है, बहुत आसानी से मिलता है।
This is with regard to IA number 4448 is with regard to awardee number 3. Who is appellant number? Biglal Vedia.
Biglal Vedia.
He is the appellant number. बिगलाल वेदिया तो इसमें है ही नहीं।
Yeah, what is already?
He's not there.
W and Sikandar maybe are already there.
Already their name has been given, madam.
इनके कौन है लीगल ईयर्स?
They are W and Sikandar Bedia.
They are already.
Already we have been added as a party member, as a beneficiary.
देखिए आईए नंबर, कोई ऑब्जेक्शन है आपको? आईए नंबर 4448 of 2022 in FA number 164 of 2018. Counsel for the appellant has submitted that the awardee number 3, namely Biglal Bedia, son of Tulsiya Devi, in LR case number 73 of 2012, died on 16/3/2018, leaving behind his two sons, namely W. Bedia and Sikandar Bedia, aged 28 years and 21 years, respectively, who are the legal representatives. He has submitted that this appeal was filed on 18/5/2018, making the aforesaid two legal representative of Biglal Bedia as appellant. It is in connection with defect number. The learned counsel submits that in view of the aforesaid the defect in connection with not making Biglal Bedia as appellant be ignored and Abdullah Bedia and Sikandar Bedia be permitted to pursue this appeal. Correct? The learned counsel for the respondents has no objection to the player considering the aforesaid submission.
One more IA is there.
Considering the aforesaid submission, IA number 4448 of 2022 is hereby allowed, and accordingly, Biglal Bedia is to be now represented by the other two appellants, namely W. Bedia and Sikandar Bedia. However, this order has been passed only for the purposes of the present case and for no other purpose. Succession certificate जरूरत होगा तो आपको वहाँ पे देना पड़ेगा.
मुखिया से मुखिया issues.
वो हम नहीं जानते. मुखिया उखिया का तो कोई डॉक्यूमेंट आप लगाए भी नहीं है, ना ही हम लोग को उससे मतलब. आइए बताइए दूसरा वाला.
That is the appellant number 1, namely Rameshwar Bedia,
कब उनका डेथ हुआ?
16/9/2021. Living behind wife Charki Devi, son Bhuneshwar Bedia and Mukesh Bedia.
नंबर 4 का भी डेथ हो गया.
Number 4, Shambhu Bedia also expired, leaving behind two sons Kanchan Bedia and Fulchand Bedia.
देखिए सबका वकालतनामा फाइल किए हुए हैं.
Work here.
आइए नंबर 4476 of 2020. The learned counsel for the appellant submits that this interlocutory application has been filed for substitution of appellant number 1 who died on 16/9/2021 and appellant number 4 who died on 13/5/2020. He further submits that the name of the legal representatives have been mentioned in paragraph 3 and 4 of the interlocutory application respectively. Counsel for the respondents has no objection to the prayer for substitution. Accordingly, the IA number such and such is allowed. IA number 4476 of 2022 is allowed. Counsel for the appellant is directed to delete the name of appellant number 1 and appellant number 4 from the cause title and insert the name of legal heirs and successors whose name have been mentioned in paragraph 3.
3 and 3.
सिर्फ पैरा 3 में ही है, 3 and 4 नहीं है.
3.
Paragraph 3 of the interlocutory application. ये जो आपका आप जितने भी इंटरलोक्यूटरी एप्लीकेशंस फाइल करते हैं ना, दिस इज नॉट एज पर द नॉर्म्स ऑफ द झारखंड. आगे से रिजेक्ट कर देंगे. पढ़ने में भी दिक्कत होता है. इतना मोटा चश्मा लग गया लेकिन फिर भी हमको दिक्कत होता है. ठीक है, किसी कारण से ये सब लगाया गया है कि एजेड लोगों को कम रूल्स को फॉलो करिए. ठीक है,
ठीक है, चलिए.
ओके. It is made clear that this substitution is made only for the purposes of the precedence and no more.
In both the cases, the limitation is also there of 26 days. That may kindly control my case.
आइए फाइल किए हैं.
नहीं, limitation पर we will ask you.
Already in several cases, I have given that limitation has been controlled.
26 डेज का लिमिटेशन पे आप आर्ग्यू करना चाहते हैं.
मतलब जो 26 days apart from
बाकी सब केस खत्म हो गए. 1 अप्रैल में 26 डेज का लिमिटेशन इन लैंड एक्विजिशन मैटर.
नहीं, क्वेश्चन फ्रेम ही नहीं किया वहाँ पर. इशू ना जो आप देखेंगे कि इशू इस पर डिस्कस ही नहीं हुआ.
किस पर?
वहाँ पर भी लिमिटेशन पे
आपने नहीं रेस किया होगा इसलिए नहीं डिस्कस हुआ. आइए बताइए कौन सा.
382.
One is 3824.
आइए नंबर 3824 of 2022. This petition has been filed seeking condonation of delay of 26 days. It has been filed for condonation of delay of 4 months and all. However, the counsel for the appellant has submitted that, as per the office note, the delay is only of
26 days.
not correct. 1687 days. देखिए बिना रिकॉर्ड पढ़े ना मेरे सामने एक शब्द भी मत बोलो. Condonation of delay of 4 months 27 days. However, as per the office note, there is delay of 1687 days. Counsel for the appellant seeks attendance and prays for time to file up, to take appropriate steps and to file appropriate petition. और बताइए दूसरा केस. ये तो आप किसी दिन बहुत गलती करा.
ऐसा था 2 sets में फाइल हुआ था. Otherwise, in the other cases, only 26 days.
दूसरा केस हो गया. एक ही केस में कर दीजिए. हाँ, इसको कब रख दें बताइए. आप चेक कर लीजिए, रिकॉर्ड चेक कर लीजिए. देखिए हमारे बातों पे मत चलिए, आप अपने रिकॉर्ड से चलिए.
Other cases are fixed on 20th February.
20th of 20 तारीख.
20 तारीख लेकिन इतना जल्दी हो पाएगा कि
Post this case on 20th February.
मतलब the argument is still by this
आप देख लीजिए.
एडमिशन में
आप लोग का एडमिशन में भी है 5 केस.
5 केस.
इसको एडमिट कर लेते हैं. नहीं
Condition item 32, first appeal 176 of 2018. Looking at item 33 to 26.
FA number 176 of 2018 with the analogous cases. सब एक ही अवार्ड से आ रहा है.
सब एक ही अवार्ड से आ रहा है, एक ही विलेज का है.
The learned counsel for the applicant has submitted that all these cases arise out of common award.
कॉमन
Similar matters are coming on.
20th of February.
उसमें रिकॉर्ड कॉल फॉर हो चुका है.
रिकॉर्ड आया कि नहीं आया इस अटेम्प्ट में?
कॉल फॉर हुआ है.
प्रोबेबली इट्स नॉट.
कुछ पता ही
नहीं, आप तो ऑफिस में पूछे तो बोला कि ये
कॉल फॉर कोर्ट में ना होगा तब ना आएगा रिकॉर्ड.
it may be call for I am ready to pay the some
He submits that the records be called for and similar matters are coming up on
20th February.
20th of April. Admit, call for the records from the concerned court upon deposit of special messenger cost by the applicant by Monday. ये तक कर देंगे. और एक चीज़ और, ये ऑर्डर टाइप करके अपलोड कर रहा हूँ. दूसरी चीज़ प्राइवेट रिस्पोंडेंट है.
No, nobody. Only railway and state.
Railway and state are there. Respondents. Counsel for the railways.
Really only one case I'm attending.
भाई ये रेस्ट का क्या मतलब है भाई, आप लोग को समझ नहीं आ रहा है. रेलवेज के यहाँ पे स्टैंडिंग काउंसिल कौन?
नहीं आजकल ये हो गया कि जो यूनियन गवर्नमेंट के काउंसिल होते हैं उन्हीं को अलाउड होता है. तो एसजी जो लोग फाइल अलॉट करते हैं, द वन फाइल हैज बीन अलॉटेड टू द रेस्ट.
What about others?
अभिजीत नॉट अभिजीत इज
अभिजीत तो थे यहाँ पर. The memo of appeal has already been served upon the standing councils representing the respondents. Accordingly, no notice need be served. बोलिएगा भाई अपना, आप रेलवे से हैं? स्टेट. आप उनको बोल देंगे. आप लोग वकालतनामा नहीं फाइल करते हैं रेलवे का? पूरा बैच. पोस्ट ऑन 20. आपने तो मिस्टर अनिल कुमार को बोलेंगे आप कि सारे केसेस में जो कौन सा सीरियल नंबर है, कौन सा
22
22 to 26 में मिस्टर प्रशांत पल्लव है क्या यूनियन ऑफ इंडिया में? है ना, रेफरेंस तो पढ़ते हैं.
वो हम एसजी को बता दें.
जो भी है उनका नाम अपीयर कर रहा है, हम एज्यूम कर रहे हैं कि वही लोग अपीयर कर रहे हैं.
This case for final so item 3, second appeal 61 of 2017.
Appellant.
It's the judgment of performance. I was a defendant in the court below. Suit was decreed, appeal affirmed, therefore made the second appeal.
Let us see the question of law and then we'll see the.
Lord, before my Lordship sees the question of law, brief facts, my Lord, if Lordship permits me. My Lord, this is a case, my Lord, where suit has been filed by the plaintiff for declaration of right title interest, along with cancellation of Exhibit E, which is a sale deed in my favor, that is dated 11/10/2001 as null and void. 11/10/2001 in my favor, not Exhibit E, as a null and void.
What is the date of filing suit?
Lord, suit was in the year 2002 itself, within limitation.
This is a sale deed.
Sale deed. Let's say case of double sale deed, my lord. My sale deed is subsequent. Therefore, my lord, they have filed for cancellation of second sale deed.
What is their sale deed?
My lord, their sale deed is dated, my lord,
Exhibit.
Exhibit E. That is, my lord,
That is their sale deed.
that is their sale deed.
Where is your sale deed?
My lord, my sale deed is exhibit E. My sale deed is exhibit E, and their sale deed is exhibit 2.
Exhibit.
My lord, that is dated, my lord, 20th March 2001. 20 March 2001.
Why did they ask for cancellation of your sale deed?
Yes, my lord. I'm coming, my lord. Now the facts, my lord, goes like this, my lord. That the ex-landlord, then, my lord. This is an admitted case, my lord, somewhere, my lord. That admitted the ex-landlord, my lord, acquired the property earlier, my lord, under section 25A of the regulation of Santhal Pargana. There was a provision that ex-landlord can acquire a property at the behest of anyone, my lord, and thereafter it has to be paid by the Rayyat, my lord. Just like the acquisition, my lord, nowadays going on. Private acquisition was also permissible. Subsequently, it was repealed, my lord. In the 1939 around, my lord, the land was acquired by the ex-landlord in favor of his wife. My lord, the ex-landlord name was Narsingh Charan Nandi Chaudhary, and its case was LA case number 7 of 1935-36. Land was acquired, my lord. Thereafter, my lord, the ex-landlord and her wife, my lord, she demised, and thereafter the property was inherited by his son. My lord, son's name is Har Gopal Nandi Chaudhary. May I proceed?
Yes.
Yes. My lord, thereafter, my lord, this Har Gopal Nandi, the successor in interest of the ex-landlord, my lord, sold 4 decimals of land to one Mohan Lal Burman. My lord, the date is not there, my lord, when he sold.
Yes. So, son acquired by succession.
Yes, ma'am.
He did not acquire the property by virtue of being the son of ex-landlord.
Inheritance, my lord, by way of inheritance.
There would be 2 inheritance, no? He acquired the land in the name of the wife. So the property became of that of the wife.
Yes.
Therefore, this is inheritance through wife or inheritance through landlord.
Lord, it may be either, my lord, because it is not
It
in
will not
dispute.
make any difference.
Yes, it is not in dispute. Thereafter, my lord, this is an admitted case, my lord, I am going on. Thereafter, my lord, this Har Gopal Nandi Chaudhary, my lord, sold the property, 4 decimals of land, my lord. This is plot number 3233 / /A/15, measuring in area 4 decimals of land, in favor of Mohan Lal Burman. My lord, with due respect, my lord, the date is not mentioned, my lord, in the plaint or the WS, my lord. This is an admitted case. My lord, now thereafter, my lord, this
What is the
Mohan,
nature of transfer?
my lord, the sale deed perhaps, my lord.
Registered or
Perhaps
unregistered?
registered, perhaps registered. It is only mentioned in the plate, my lord, it says but land was transferred. My lord, thereafter, this Mohan Lal Burman, my lord, in his turn, sold this property, which is, my lord, dated 19/12/1985 by virtue of a registered deed. This particular 4 decimals of land, my lord, to one Raja Muni Mandal. Raja Muni Mandal. My lord, this document is Exhibit D. My lord, this Raja Mani Mandal, after coming in possession, my lord, he sold the property. My lord, up till now, my lord, this is the admitted case, my lord. That Raja Mani Mandal is the owner of the property, my lord. Now, my lord, here, my lord, the plaintiff's case goes on, my lord. This Raja Mani Mandal, my lord, sold the property in the year 2001, 28/3/2001 by virtue of Exhibit 2 in favor of Anandi Devi, the defendant number 1, my lord. Sorry, the plaintiff. I'm sorry, the plaintiff.
Exhibit 2
Exhibit 2, the plaintiff.
to claim.
The date is Raja Mani Mandal sold the property, my lord, in the year 2001. Lord, it is further case, my lord, that after coming in, after acquiring the property, she mutated her name. Lord, there is no document as such, my lord, with respect to the mutation. And thereafter, my lord, they came in possession of their property. Sometimes, my lord, in the year 2001 itself, my lord, on 11/10/2001, they came to know that the same vendor who has sold the property to the plaintiff Anandi Devi, had also sold the property in favor of the defendant number 1, which is the appellant here in Milord. Her name is Milord the Shobha Devi.
How many defendants were there?
Milord, there are altogether 2 defendants.
Why?
Milord, one is my Milord. This is the he is the plaintiff. She is the plaintiff. I am the purchaser. I am defendant number 1, and the vendor is also made a party. Both the common vendor.
That is
And thankful to
Rajmani Mandal is also.
Rajamani Mandal is also, but this is defendant number 2.
Defendant number?
2.
Did he contest?
Milord, he contests, Milord, and he filed
Will come.
WS also.
Will come. Same vendor sold the property to the defendant number.
Defendant number 1 and 2. Defendant number 1, Milord, defendant number 1 is prior in time. So plaintiff is prior in time, and defendant number 1 is subsequent. In the March, he sold Milord to the plaintiff, and in the October, plaintiff sold to me. There are
So with respect to the same description of
Yes.
property, there
Yes.
are two sale deeds.
2 sale deeds.
One in favor of the plaintiff, another in favor of defendant number 1, executed by the same person who is defendant number 2.
Yes.
Correct?
Yes. This is the case of the plaintiff.
Okay.
Therefore, Milord, they filed a suit for declaration of my deed being subsequent in time as null and void. I filed WS, Milord, on being noticed. I appeared and I contested, Milord, stating inter alia that the property, the suit in question, property in question was the defendant number 2 had entered into an agreement to sale with this particular defendant on 30th October 2000, which is Exhibit B. And in pursuant thereto, the defendant number 1 had paid 15,000 as an earnest money, and followed with delivery of possession. And therefore, my lord, my deed is a valid one, and the vendor has not executed any deed in favor of the plaintiff, and it's a case of impersonation. This is my case on the WS. Defendant number 2.
Just a moment.
Sorry. One thing more I missed.
Defendant number, yes.
I think one thing in the case of the further case of the plaintiff is that the vendor of both the parties were not acquainted with Hindi signature method. Therefore, and in my deed he has put a signature in Hindi, and in his deed he has put a signature in Bengali. Therefore, he was acquainted in Bengali language. He was not conversant with the Hindi. This is the further. Therefore, my lord, my
What
deed
is the case of the vendor?
My lord, vendor case is, my lord, that I had never executed a deed in favor of the plaintiff, and he is very much conversant with the Hindi language. And the sale deed executed in favor of the plaintiff is void, fake, and he also ratified that defendant number 1 had entered into an agreement to sell with him, and he has delivered possession.
So, but the prior sale deed, which was fake or not executed by him, has not been challenged by him.
No,
Why?
it was not challenged.
So it is staring on the face
Yes.
of it.
That it's a weak point, in this phase. This is the main issue where the court below has set aside the past and agreement. I will satisfy lots of that aspect also. Therefore, the trial court, on the basis of all these facts and circumstances, decreed the suit, stating in area that the agreement to sale, the version of the agreement to sale alleged to be in the Exhibit B has not been whispered in the sale deed, my sale deed. Therefore, the facts with related to agreement to sale is bad. He further, my lord, that my deed is subsequent in time. Therefore, this case was declared invalid. Appeal, my lord, it was reversed.
Let me just write it. The learned counsel for the appellant has submitted that though the background in connection with the suit property has been narrated in the pleadings, but it is not in dispute that the property stood in the name of Rajamani Mandal by virtue of registered sale deed dated 19/12/1985 within bracket Exhibit D. Rajamani Mandal was defendant number 2 in the suit. He submits that as per the case of the plaintiff, defendant number 2 executed a sale deed dated 28/3/2001 within bracket Exhibit 2, and it was their claim that they came in possession of the property and mutation was also undertaken, but no document of mutation has been produced by the plaintiff. He further submits that the same vendor, that is Rajamani Devi within bracket defendant number 2,
Rajamani Mandal.
Mandal, that is defendant number 2, was said to have executed another sale deed dated 11/10/2001 in favor of defendant number 1, and it was a case of the defendant number 1 that there was an agreement of sale dated 30/10/2000 within bracket Exhibit B with defendant number 2, and an amount of rupees 15,000 was also paid to defendant number 2 by way of earnest money. It was coupled with delivery of possession. He submits that it was the case of the defendant number 1 as well as defendant number 2 that no sale deed was executed in favor of the plaintiff, being Exhibit 2, and the sale deed was executed through impersonation. He submits that the learned trial court referred to the sale deed in favor of defendant number 1, which was marked as Exhibit E, and observed that the Exhibit E did not refer to any agreement of sale, much less agreement of sale dated 30/10/2000 within bracket Exhibit B, and has also held that the sale deed of the plaintiff was prior in point of time and accordingly had victory placement. Or
Wait to submit.
इस केस में
This is kind of there is no delay of 67 years. There is something wrong with the staff report.
कोई बात नहीं, आप जाके स्टाफ रिपोर्टर से लीजिए, हम क्या कर सकते हैं।
We have tried to file the new.
आप एक्सप्लेन कर दीजिए ना अपने एफिडेविट में। ऐसे देखिए कोई केस इस तरह से चल रहा है, इसका हिस्ट्री इतना लंबा चौड़ा है, ऐसे बीच में आप कैसे उसको बोलते हैं। अब आप एफिडेविट फाइल करके एक्सप्लेन कर दीजिए कि डिले नहीं है, तब हम लोग डिसाइड करेंगे स्टैम्प रिपोर्टर का गलती है कि किसका गलती है। वैसे आप एक बार स्टैम्प रिपोर्टर से समझ लीजिए, दैट इज बेटर।
Now, my lord, may I request my lord to see the questions of law?
यस
Deeply organized. My lord, this is order dated 4/12/2018. My lord, first question of law. My lord, may I read the full text, my lord?
यस यस
In heard the learned conspiracy, the appellant, who is the original defendant number 1, the dispute between the parties is that the appellant had purchased the land mentioning 4 decimals of land from original defendant number 2 while registered deed number 1137 dated 11/10/2001. As per the pleadings, the plaintiff purchased the same suit land from defendant number 2 while registered deed number so and so dated so and so, that is 7 months prior to the defendant number 1. Defendant number 1 had appeared in the suit and filed written statement taking a plea that the registered document relied upon by the plaintiff was fake one, as defendant number 2 was the defendant number 2 was the executed on the said deed. In view of the effort, in view of the effort pleading, the present second appeal is admitted following substantial questions of law. Whether the learned trial court as well as learned lower appellate court had committed gross error while deciding the main issue, whether the sale deed number so and so executed by defendant number 2, the vendor of Rajamani Mandal in favor of plaintiff is lawful and valid, whereas the vendor Rajamani Mandal denied the execution of sale deed number 388 of 2001 in favor of plaintiff Anandi Devi nor the vendor Rajamani Mendal have examined to prove the said sale deed. Note second, whether the learned trial court as well as learned lower appellate court had committed a gross error while deciding another issue, whether the sale deed number 1137 of 2001 executed by defendant number 2, the vendor of Rajamani Mendal in favor of defendant number 1 is void, illegal and inoperative in law, whereas the vendor Rajamani Mendal himself admitted the execution of sale deed number 1137 of 2001 in favor of defendant number 1, Sobha Devi, in his written statement. Third, whether the learned lower appellate court as well as learned trial court as well as lower appellate court have committed a gross error and not considered the agreement executed by defendant Rajamani Mendal in his favor in favor of defendant number 1 Sobha Devi with regard to the sale of land in question. Fourth, whether the learned trial court as well as the lower appellate court had committed gross error and not verified the signature of the vendor Rajamani Mendal by any handwriting expert or by FSL laboratory. Fifth, whether the Lord, in order to answer me, Lord, this, Lord, I will.
Yes, yes. हम कहीं भी देखें, हम कभी कभी कुछ सोचते भी रहते हैं, लेकिन आई एम यूज्ड टू मल्टीटास्किंग. आप चिंता मत करिए, आपकी हर एक बात हम सुन रहे हैं.
Lord, in order to satisfy, Lord, now there are two issues, my Lord. Whether, my Lord, if Lordship may kindly have, my Lord, the findings of the appellate court first, my Lord, before I answer any of the answer to the questions, my Lord. Lord, in trial court judgment, my Lord, the facts have been narrated, the evidence have been led in page number 12, my Lord, the parties, my Lord, the DWs and PWs are there, my Lord. Thereafter, my Lord, the page number 13, PWs, my Lord, depositions are there. Page number 15 also is continuing. Page number 17 onwards, my Lord, the defendant side witnesses are examined. And now, my Lord, page number 20. My Lord, from here, my Lord, findings.
DW2 was examined as a witness.
My Lord, he died, my Lord, therefore he could not be examined during the pendency. Therefore, my Lord, his wife was substituted and sons, my Lord, they were examined. And they also adopted the written statement filed by the husband.
They had no option
Yes.
but to adopt the same.
Yes, ma'am.
But he was not examined.
He was not examined, but my Lord, he in the witness, how can he, my Lord, even with the fate of Almighty, my Lord, he devised, my Lord, he could not. But in the affidavit, he swear. Now, my Lord, the court, my Lord, had considered, my Lord, that he was not acquainted with the Hindi, my Lord. I will answer to that, my Lord. Lord, kindly see paragraph number 14 onwards. The court, my Lord, has considered this is a suit as a specific performance, my Lord, and had dealt with the entire findings as such. Page number 20, paragraph number 14 onwards.
Where are the issues framed?
My Lord. My Lord, issues are at page number 10. Appellate court judgment, page number 10. 10 and 11.
The para 8 of the trial court judgment.
Yes.
Are the issues? In the sale deed executed by defendant number 2 in favor of defendant number 1, is there any mention of consideration amount?
Yes.
Is there any deduction of at least 20,000 paid earlier, 15,000 paid earlier?
Let me know. I have not verified
Because
that.
admittedly that has not been referred to, but is there any deduction of any amount called 15,000 paid earlier?
Need to verify, my Lord. Need to verify.
Exhibit बताइए.
I will let you know. This is exhibit. Exhibit E.
Exhibit 2, correct?
E-mail.
Your Lordship, this has been taken note by the trial court that there is no reference of earlier agreement in the sale.
No reference. There is no mention about any deduction of amount that this has been already
I
paid.
don't think anything.
Let us check, because that will certainly have a bearing in this case. Exhibit 2,
This is
Exhibit E.
exhibit E-mail.
Exhibit E, correct? And then value of the property is 60,500.
Nothing has been mentioned. No, it is not mentioned.
60,500 paid today.
It's a total consideration.
No, it is paid today as per the deed itself. Para 1. Internal page 6.
Yes.
In pursuance of the aforesaid agreement and in consideration of rupees 60,500 only paid by the purchaser today.
And the receipt thereof the vendor by hereby
Yes.
acknowledge. Yes, ma'am.
So entire consideration amount was paid. There was no adjustment of any
Yes.
amounts
Yes.
mentioned. So
Yes.
this particular deed by any stretch of imagination cannot form a part of your part performance under section 2 exhibit B.
No, this is not a case, not a part of
No, let us see.
Yes,
Let us be very clear on
Yes,
this
ma'am.
that exhibit B has no bearing in this case.
No, yes. We can exclude that also. Not doesn't make any difference. My lord, page number 10 we were reading, my lord. My lord, in this case, my lord,
Of trial court judgment.
trial court, my lord, appellate court judgment or trial court judgment?
First trial court judgment.
My lord.
Limitation, cause of action, whether the defendant number 2
My lord,
3 and 4,
para number, my lord?
3 and 4, para number 8 of
8.
that.
My lord, the issues, my lord. Issue number 3, 4 and 5 all are dealt together, my lord. May I place, my lord, page number 12 onwards the finding is there.
Yes, please.
Issue number 3, 4 and issue number 5. These are three issues are interconnected with one another and therefore these three issues have been taken jointly. Issue number 3, so and so has been referred to. Now para number 15. The sale deed number 388 of 2020 March 2001 is exhibit 2 and the trace map attached with the sale deed is exhibit 2 by A in this case. The signature of the typist was marked exhibit 1 and the signature of Rajamani Mandal in Bengali language on various pages of this document were marked exhibit 9 to 9K series on this document. The sale deed number 113 dated 8/10/2001 in favor of Shobha Devi, which is exhibit E in this case, is signed by Rajamani Mandal in Hindi language. Rajamani Mandal himself has appeared as a defendant number 2 and his written statement has stated that he has not executed this deed during the pendency of the suit. He has died and his evidence could not be recorded. After his demise, death legal representatives were made as a party to this suit. In her plaint, the plaintiff has stated that Rajamani Mandal was not knowing Hindi language and in order to defraud plaintiff, he has learned writing in Hindi language recently. Defendant number 2, exhibit 2, that is sale deed till number 388 dated 20th March 2001, shows that this document was executed on 28 February 2001 and Rajamani Mandal has transferred his interest in subplot number 3233A50 to Anandi Devi in consideration with the amount of ₹61,000. This document was registered in the registry office of Jamtara on 20th March 2001. Witnessed by Vishnu Prasad Mandal, Munna Kumar Poddar and Mahesh Mandal have also marked their signatures on this document. The scribe Manik Chandra Sarkhel has given certificate that the content of this deed have fully been read over and explained to the executant, who has admitted the same to be correct and has put his signature on it. The oral evidence has been given in support of his document and from the side of defendant first party, witnesses have been examined and the plaintiff's second party have been cross-examined to show that this document is not executed by Rajamani Mandal. Now, not the depositions are there.
This Munna Mandal, Munna Kumar Poddar and Mahesh Mandal.
Yes, ma'am.
They were examined as witnesses.
Yes, but this
Munna Kumar Mandal is there.
Munna Kumar Poddar is the daughter,
Sorry,
is the
yes.
son of plaintiff, And my lord, this Mandal, my lord, this Vishnu Prasad Mandal is the son of defendant number 2. My lord, son of defendant number 2.
Vishnu Prasad Mandal.
Perhaps Vishnu Mahesh Mandal is my lord, the son of. No, Vishnu and Mahesh both are the sons of defendant number 2.
These two persons have been examined?
Yes, ma'am, they have also been examined. My lord,
Mahesh Mandal, DW13.
and Munna Podar is PW9.
That I have seen. And this other one has not been examined.
And one they out
Vishnu
of
Prasad Mandal
has not been examined.
Continue, please.
My lord, shall I proceed with
Yes,
the
yes.
depositions also?
No, not the deposition. You just come to the findings.
My lord, the findings, lordship may kindly find, my lord, from page number 18 onwards, para 32. My lord, the Pujari also an examined who has done the earth-breaking ceremony. My lord, para 32, page number 18. May I please?
Yes.
On the perusal of the entire pleadings of the parties and evidences discussed above, it is clear that the plaintiff has brought the suit on the ground that the sale deed number so and so dated 20 March 2001. She has acquired the suit land and the principal defendant is trying to disturb her peaceful possession on the basis of an illegal sale deed. Defendant's side says that Rajamani Mandal has not executed sale deed in favor of the plaintiff. Further, the case of the defendant's side is that Rajamani Mandal has taken an advance of rupees 15,000, executed agreement for sale and handed over possession to the land to the defendant. Under the doctrine of part performance, under section 53A, the Transfer of Property Act, their possession has to be protected. Entire evidence on this point has been discussed above. The witnesses examined from the side of the plaintiff have clearly told that Rajamani Mandal has executed the sale deed, and before the registrar at the time of the registration of this document, he was identified by his own son, Vishnu Prasad Mandal. The oral evidence brought on record supported by the documentary evidence is registered as sale deed number 2, seems reliable. Defendant's side has taken a plea that Rajamani Mandal has appeared in this case and has filed written statement that he has not executed the sale deed in favor of Anandi Devi. They have also referred statements of the witnesses of the defendant, second party, wife of Rajamani Mandal and son of Rajamani Mandal, who have told that Rajamani Mandal has sold the land to Shobha Devi, wife of Shravan Kumar Gupta. DW10, Surji Devi is the wife of Rajamani Mandal. In his cross-examination, could not identify Shravan Gupta and his family members. Evidence brought on this point from the side of the defendant is weak, hearsay, and without any basis. The claim of defendant that Rajamani Mandal was not the executant of the sale deed and some fake person has produced in the registry office to execute the registered sale deed is not supported by any reliable evidence. In present case, Rajamani Mandal, by executing sale deed dated number sale deed on 28 February 2001, has transferred the right title interest of suit property to Anandi Devi after receiving the consideration amount of rupees 61,000. She was a complete sale was complete on that date, and this sale deed is registered on 20th May 2001. The principal defendant claims her right to the property will be protected under the doctrine of part performance under section 53A of the Transfer of Property Act. Learned Senior Counsel for the principal defendant has referred the Supreme Court, Honorable Supreme Court in so and so in support of his argument on this point. In the instant case, the document agreement to sale dated 30th October 2000, Exhibit B, says that the advance of rupees 15,000 is acknowledged and the possession of the land has been given to the Shobha Devi. The document agreement to sale dated 20th December 2000, Exhibit C, says that the advance of 15,000 is acknowledged and the possession of the land has been given to the Shobha Devi. The fact of the transfer of possession of the land to Shobha Devi on 30th October 2000 is not mentioned in the document agreement for sale dated 20 March December 2000, Exhibit C. The sale deed number so and so, Exhibit E, is silent about the previous agreement and possession in its para 2 mentions that the said property will be quietly entered into, and upon the said it will be held and enjoyed by the purchaser without any interruption. There is no documentary evidence or oral evidence to believe that the Shobha Devi is in possession of the disputed property after the alleged agreement dated 30th October 2000. For operation of Section 53A transfer property, it is essential that the transferee must, in part performance of the contract, has taken possession of the property, and he/she must have some act in furtherance of the contract. Here, the principal defendant is not seeking any protection against the transferor.
The judgment is primarily on the ground that if the defendant was saying that this is a forged document, it was for the defendant to take a appropriate stand and steps to take to send the document for.
This is wrong. This is wrong. Under Section 101, in the plaintiff my lord has said that the my lord, if a lordship permit, may I read the
Firstly, that document was not subject matter of the suit.
which document?
That was not under challenge.
Which document?
The document of the plaintiff, the sale deed of the plaintiff was not under challenge.
Yes.
Right?
No.
It was not under challenge. And the defendant said that this is a forged document.
Yes. The
Forged
plaintiff
document.
said that this document by the execution made by because he was not acquainted with the Hindi, therefore this document is a void document.
No, plaintiff said the case of the plaintiff was simple. They said that this document was executed in their favor much prior in time, and therefore they had the title.
And further, my lord.
And further, they said that so far as your document is concerned.
One thing is, my lord. They further said, my lord, the Rajamani Mandal, my vendor, the common vendor, my lord, was not acquainted with the Hindi writing. My lord, it was their assertion.
Was it your case that the document of the sale deed of the plaintiff was through impersonation or a
Yes.
forged one?
Yes.
Who will take steps for examination?
My lord, first, my lord, they alleged that he was not acquainted with the Hindi, and it is not his signature in my sale deed. In the plaintiff, my lord, if lord's permit, may I read the.
Did the plaintiff say that the document executed, the sale deed executed by defendant number 2 was forged?
Yes.
Forged?
Therefore, my lord, they said that he
Forged.
was not acquainted with the Hindi, my lord.
Maybe not acquainted. Did they say that their sale deed is forged?
My lord, may I permit to read?
Yes, you read.
Yes.
That the plaintiff would say that their sale deed is forged.
Yes.
Is that so? Plaintiff said that it is forged.
Absolutely not. I'll
It's
read out the-
unheard of. Plaintiff
No, no.
अपना deed को बोलेंगे
I'm-
कि forged है।
अपना डीड के लिए नहीं, my lord, वो मेरे डीड के लिए.
आपके
नहीं,
डेट के लिए तो बोलेंगे, लेकिन आप भी तो इनके डेट के लिए फोर्स्ड बोल रहे थे।
well, हम तो बोल ही रहे हैं, my lord.
हाँ, तो कौन लेगा स्टेप फॉर एग्जामिनेशन?
प्लेंटिफ कौन हुए? प्लेंटिफ ये हुए.
प्लेंटिफ ये हुआ है?
इन्होंने पहले अलेज किया कि वो राजा मनी मंडल का सिग्नेचर नहीं है.
नहीं नहीं
नहीं,
ये हम नहीं बोल
ऐसा कैसे?
हम बोल रहे हैं what he did was that he started writing in
Yes,
Hindi.
yes.
He is the person who is executing both the documents.
एक में हिंदी में साइन
हाँ,
करे, एक में बांग्ला में साइन।
exactly. Mine
कोई
deed
ऐसा
is
इम्पर्सोनेशन का केस प्लेंटिफ अपने डीड के बारे में बनाएगा?
अपने डीड के बारे में नहीं, मिला मेरे डीड के लिए बोल रहा हूँ.
आपके डीड के बारे में बोले
हम
ना?
पढ़ दे रहे हैं वो पैरा.
तो भाई आपने बोला, दो चीज आपने बोला, ठीक है? पहला चीज बोला कि इनका डीड फोर्स्ड है।
हाँ,
He
मैंने
said
बोला.
so,
हाँ.
ठीक है? जिसका कोई अलग से चैलेंज भी नहीं।
नहीं.
दूसरा चीज आपने बोला पार्ट परफॉर्मेंस के तहत आपको एक सब्सिक्वेंट सेल डीड हुआ।
हाँ.
पार्ट परफॉर्मेंस का केस तो आपका बनता ही नहीं।
नहीं.
कहानी खत्म वहां पर पार्ट परफॉर्मेंस की। अब इनका डीड फोर्ज्ड है कि नहीं है, इसके लिए हैंडराइटिंग एक्सपर्ट का एग्जामिनेशन का पिटीशन कौन फाइल करेगा?
ये फाइल करेंगे.
क्यों फाइल करेंगे?
इनका केस था, मैं लॉर्ड में, वो क्यों हिंदी नहीं जानते थे?
नहीं जानते नहीं थे, लेकिन सीख के साइन किए। इन्होंने ऐसा नहीं बोला कि इन्होंने नहीं साइन किया।
यही बात बोले.
नहीं
नहीं एक मिनट. Subject to correction. Your Lordship, we were not aware about who has signed. So what we said was, now during evidence we have said that it was because it was subsequent to a point of time. Therefore, in terms of Section 48 of the Transfer of Property Act, the earlier document would prevail. This
That's
was
right.
the essential condition.
That's right.
This was the main contention.
This is where the parties joined issues.
Yes, and my contention is simple, that once my deed is earlier in point of time, second deed absolutely
Did you
goes in terms of
say
section
that your deed is forged?
No, absolutely.
तो बताइए, वैसा ही
बोले
बोलेंगे।
लॉर्ड, ये कैसे बोल सकते हैं?
तो वही ना, अगर मान लीजिए आप इनके डीड को फोर्स्ड बोल रहे हैं तो उसका हैंडराइटिंग एक्सपर्ट से एग्जामिनेशन का पिटीशन कौन फाइल करेगा?
मिलॉर्ड एक मिनट मिलॉर्ड मैं क्लैरिफाई कर दे रहा हूँ, ये 2 मिनट
और शॉर्ट कर दें, शॉर्ट ये कर दे रहे हैं that despite the fact that he was required to appoint handwriting expert and get the document examined, then also what we proved was that the same vendor, he had several cases pending before the
सब
court
डॉक्यूमेंट्स
where he had, yes, where he had signed in Bangla, and those documents were marked without objection. They did not even lead
There is
any.
a lot of discussion of so many documents.
They did not lead any evidence
तो
whatsoever.
अपने तरफ से बता रहे हैं मिलॉर्ड, तो ठीक ही है मिलॉर्ड। एक कंप्लेंट का एक पैराग्राफ हम पढ़ रहे हैं। The plaintiff submits, मिलॉर्ड I am making the complaint मिलॉर्ड reading para number 11. The plaintiff submits that practicing fraud and misrepresentation, the said Rajamani Mandal once again alleged resold that on that 4 decimals to Srimati Shobha Devi, the principal defendant, herein executing another deed. आगे पढ़ रहे हैं। The token of said execution, Rajamani Mandal signed the deed in Hindi. The second deed is registered in book number 1 so and so 2001. That to the knowledge of the plaintiff, Rajamani Mandal do not know Hindi. मतलब इनका assertion है he does not know Hindi, but someone practicing fraud and misrepresentation and actually executed the second deed number so and so in favor of the principal defendant.
ठीक है,
मतलब ये allege कर रहे हैं।
ये एलेज कर रहे हैं, वो आप मान लेते हैं कि दोनों डीड वैलिड है।
नहीं कैसे मान लेंगे?
नहीं, लेट अस एज्यूम फॉर अ मोमेंट, ठीक है। अब तो सेक्शंस 44 से ना गवर्न होगा सीधा सीधी। 44 की 47 क्या है? ट्रांसफर 48
7
48 of transfer of property act.
सिंपल।
मिलॉर्ड वो उसमें मिलॉर्ड दिस इज नॉट ए सिंपल केस मिलॉर्ड, हम आगे बता रहे हैं
वेरी
इसमें
सिंपल केसेस, सिंपलीफाई कर
नहीं हमसे बता रहे हैं मिलॉर्ड, क्योंकि मिलॉर्ड मेरा प्ली मिलॉर्ड यही है कि दे हैव टेकन अ प्ली, the plaintiff has taken a plea that the fraud has been committed. This specific words मिलॉर्ड in n numbers of words मिलॉर्ड they have stated.
सब्सिक्वेंट सेल डीड 100 सेल डीड हो जाए, इससे क्या ही लेना देना है?
आंसरिंग मिलॉर्ड, अगर हम सेल डीड नहीं एग्जीक्यूट कि मेरे बिहार में कोई और आके एग्जीक्यूट कर दे तो सेल डीड को वैलिड मानेंगे हम?
आप ही पूछिए।
नहीं मानेंगे मिलॉर्ड, मेरा जमीन है, हम किसी को बेचे नहीं, मेरा डीड कोई और ले लेगा तो वैलिड कैसे
I
मानेंगे?
concede that the second deed was executed by defendant.
बस बोल दो, चल कंसेशन। चलिए आप बताइए क्या बोलना है आप?
ठीक
Second deed was validly executed by the defendant.
मिलॉर्ड, इट इज नॉट द केस बिल्कुल।
Let us assume, यही ना आप establish करना चाह रहे हैं, that second deed was validly executed by
Yes.
defendant number 2.
Yes.
Let us assume that
he
it
was
is validly
acquainted with the
executed.
Hindi also. ठीक है, he has admitted मिलॉर्ड now.
ठीक।
Milord, in order to satisfy
Not
Milord,
admitted, conceded for
concede,
the
sorry, I'm
Let us see, where do you land now?
yes. No, Milord, they say, Milord, that one thing, Milord, that court below has in the plaint, Milord, they have stated that he was not acquainted with the Hindi. Milord, this suit is of the year 2002. Milord, I have marked a document which is Exhibit F, which is a deposition in another suit of the 1991. In that case, I have deposed before the court and signed it in Hindi. Therefore, Milord, the deed was executed with me, Milord. The defendant number 2 has validly executed deed in my favor, and he has himself has deposed that he was acquainted with Hindi and not Bengali.
That's true.
The court below, my lord, so far as the issue is concerned, the appellate court has discussed, my lord, so since I have not taken any effort for a cross-examination, for sending the document to the handwriting expert or FSL, therefore, it goes against me, and therefore, this document, you cannot assail that particular document. Now, since my lord, my senior has conceded that document has been executed.
I'm conceding second document.
Second document, not the first one.
Second
The
document.
finding of the trial court was that you have not taken any steps for the handwriting expert examination of the deed relied upon by the plaintiff.
Yes. Reliable
Yes.
plaintiff, my lord, the document which has been marked as C 101 of the evidence act. Evidence, my lord, burden is upon the plaintiff to send the document to the handwriting expert. It is their case, my lord. Lord, may I-
Provided they say that the subsequent document is full,
Yes.
right?
Yes.
Right? There are two deeds. You say their deed is forged, they say your deed is forged, correct? In order to establish that your deed was forged, it was for them to take steps for examination of handwriting expert. But in order to say that their deed was forged, who has to take a step? The person who alleges?
The first, my lord, is burden upon them.
The person who alleges will have to take steps.
Yes.
You are alleging that the sale deed of the plaintiff is forged, correct? And therefore you have to take steps. With
In what-
respect to exhibit 2,
If suppose, my lord, I have not taken any steps, my lord.
So?
My lord, they have considered with respect to exhibit my deed.
yes.
My deed is
How
valid,
does that-
they have considered, my lord. Now, my
Not,
lord,
as, not valid. They say duly executed.
duly executed.
Let us
sorry.
assume for a moment.
Duly executed. Now, my lord, I have no case, my lord. As such, my lord, I have not challenged that particular deed, my lord. Is other drawback, my lord. I have not challenged that particular deed, my lord. Rather, my lord, I am not required to challenge that deed. I will argue on that also. I am not required to challenge that also. My lord, no, my lord, since my senior has considered, my lord, that with respect to the execution, my
It
lord,
is noted down noted by the court that I'll read. In facts and circumstances of this case, it appears that plaintiff has got no suspicion that Rajamani Mandal had executed both sale deeds. The court notes.
now, my lord,
Okay.
my case is. Abhi, my lord, abhi to first ही point है. Second
First
point, my lord. My lord, who is the plaintiff here, my lord? The plaintiff is Anandi Devi. My lord, this particular plaintiff has not come in the witness box. Why may she has not come in the witness box? Therefore, my lord, adverse inference has to be drawn.
Need not come.
My lord, who will depose, my lord, whether the execution was done, in whose presence document was documentation was done, my lord?
Anandi Devi was very old. That is why she did not come. There is an explanation for not coming.
My lord, I am reading the deposition, my lord, the son has deposed, my lord. मेरी माँ सन 2030 से फलेरिया के कारण चलने फिरने से लाचार है। आगे कहते हैं इनके इलाज संबंधी हमने कागजात नहीं समर्पित किया है। मिलट जब अगर है तो एग्जामिनेशन घर पे भी होता है मिलट, कमिश्नर अपॉइंट करा लेते।
सुनिए, आप ना तो रीट बहस कर रहे हैं ना सूट बहस कर रहे
नहीं
हैं।
हम अपील
आप
बहस
सीधे
कर रहे हैं।
आप फैक्ट सारा आ गया।
Yes.
अब आप अपने क्वेश्चन ऑफ लॉ।
यस
ऑल द फैक्ट्स आर देयर बिफोर अस।
यस
यू जस्ट वन बाय वन आप प्रोसीड करिए।
सो फार क्वेश्चन नंबर 1 इज कंसर्न।
यस।
Lord, I am reading again whether the learned trial court as well as learned lower appellate committed error while deciding that whether the sale deed number 388/2001 executed by defendant number 2, the vendor of Rajamani Mandal in favor of the plaintiff is lawful and valid, whereas the defendant Rajamani Mandal denied execution of sale deed so and so in favor of Rajamani Anandi Devi. The defendant number 2 has denied execution of sale deed in favor of the plaintiff. Now, my lord, my one contention is the plaintiff has not been examined, therefore adverse inference has to be drawn, and for which, my lord, I rely upon the judgment. My lord, there are several judgments also. My lord, this is 2000 AIR 2024 Supreme Court, page number 3017.
ऐसा कोई पॉइंट ऑफ लॉ नहीं बना है इसमें।
My lord, the factual
The
issue,
adverse inference, whether the adverse inference was required to be drawn or not, what is the effect of non-examination of the plaintiff? ऐसा कोई क्वेश्चन ऑफ लॉ नहीं बना।
lordship, there is a liberty, my lordship, so please can frame it. No, my lord.
I don't think that it arises in this case.
Sorry, my lord.
I don't think that such a point arises in this case.
Yes, my lord, sir.
Yes.
Now, my lord, after the execution of a sale deed in my favor, my lord, my original vendor has transferred the original deed in his possession to me and his erstwhile vendor. My lord, I purchased the property of Rajamani Mandal. He transferred that particular piece of document to me, as well as that person from whom he has purchased in 1985. He also transferred a document to me, which is marked as an exhibit document.
Which is that
My lord, this document is exhibit. Therefore, my lord, this is a.
Just a moment.
Yes.
Which is that exhibit?
My lord, this exhibit D, which is a document of Mohanlal Burman dated 19/12/1985. If my lord, the D
Exhibit D.
exhibit D, and my lord, the exhibit 2, no, Mohanlal Burman sold the property to exhibit D, my lord. This उसके बाद thereafter the Mohanlal Burman ने अपना deed भी मुझे दिया.
कहाँ?
My lord, that is the exhibitor. My lord, kindly help me. Lord, this is exhibit D में लॉर्ड एक वो है उस मैप के साथ में उसके बाद 2001 यही एक डॉक्यूमेंट लॉर्ड exhibit D.
आपका वेंडर
Yes.
कौन है? मंडल.
मंडल राजामणि मंडल.
तो ये
मोहनलाल बर्मन ने इनको बेचा.
मोहनलाल बर्मन ने जो राजामणि मंडल को बेचा और राजामणि मंडल ने तो वो डीड अपना नहीं दिया आपको, बिकॉज दैट इज नॉट एग्जिबिटेड.
राजामणि
मंडल का मोहनलाल बर्मन
बर्मन
का
ने
डीड इन फेवर ऑफ राजामणि मंडल हैज इट बीन एग्जिबिटेड?
Yes, exhibit D.
Exhibit D is 1984. This is the
1985. This is the deed executed Mohanlal Barman in favor of Rajamani Mandal. And Rajamani Mandal transferred in my favor. At that point of time, he gave the property deed also, original deed. This is exhibit D. अगर इनको बेचा था तो इनके पास में deed होना
is there
चाहिए.
any requirement in law कि original deed
No,
देना?
this is a presumption. There is a
Presumption
presumption.
पे case नहीं decide.
Under similar under section 114, there is a
There is
presumption.
no requirement in law
Therefore, when I
that
case,
the back-to-back deeds are to be given to the vendor, to the
therefore, when it's
purchaser.
case of impersonation. Therefore, अगर इनके पास अगर डीड किए होते तो डीड इनके पास में होता. Subsequent deed मेरे पास इनके पास क्यों नहीं आया? Therefore, my lord, I am trying to make out, my lord, that since the original deed is in my fair possession, my lord, I am in possession of the property. Therefore, inference has to be drawn that original title document has passed upon to me and their deed is defective. My lord, for which, my lord, I rely upon a judgment, my lord.
So this is one circumstance which stands against it.
Yes.
Further,
My lord. My lord, may kindly take, my lord, one authority, my lord. This is the 2012 DLT Delhi Law Times 525. My lord, which says possession of this original sale deed.
वो judgment है ना ये है?
Yes, my lord. उसमें है. Now it is the fourth flag here. My lord, I am referring to my lord para number 7. Lord, I put a mark upon the operating motion. The possession of this document, original title deed with the appellant plaintiff, is a very strong proof of ownership of the fruit property, being the appellant plaintiff by means of chain of title, which have been referred herein above. Lord, I am making of the chain of title is here. Lord, I could not get the direct judgment on this, but therefore, Lord, I got this. Now, Lord, the second point is.
This is arising out of land acquisition proceedings.
Perhaps.
Yes.
So who will be the claimant, my lord? Therefore, my lord, their person was claiming that I am the
So the
property.
person who was holding all
Yes.
the deeds were held to be the
Yes, in that
for the
respect.
purposes of grant of compensation.
Yes. Now, my lord, I believe, my lord, that fraud has been played. They have played a fraud by impersonating. Therefore, fraud vitiates everything. Every solved act is from the fraud. Now, my lord, lordship is asking my lordship query, put a query that since I have not challenged that particular deed, whether even then a degree can be
It was
passed.
just a passing remark.
Yes, my lord, I am answering, my lord.
You just
I am satisfying that query also, my lord. With the authority, my lord. I am not answering the error by the authority, my lord, only. Lord, if a document is void, it is not required to be cancelled. Lord, for which, my lord, I rely upon judgment, my lord. This is 2006 Supreme Court, my lord. Lordship may find it at 1, 2, 3, 4, 5th flag, my lord. Lordship, page number 60, para number 16.
प्रेम सिंह
Friends,
रोड साइड होता है एवरी डे.
और ये दूसरा इशू पे है कि अगर बच्चा अगर माइनर है 3 साल के अंदर में चैलेंज नहीं किए तो void होगा.
Every day this judgment is being cited.
I'm
Anyways.
not referring to it to para
No,
number
no, no.
16.
You please refer
Yes.
it because one judgment may have multiple
Para number
dimensions.
16, my lord. When a document is valid, no question arises of its cancellation. When a document is void ab initio, the decree for setting aside the same would not be necessary in the same in honest in the eye of law as would be nullity. Therefore, my lord, the deed is a nullity. My lord, there-
Next para नहीं पढ़ेंगे.
Yes, sir.
17 भी पढ़िए सब.
However, once a suit is filed by the plaintiff for cancellation of the transaction, it would be governed by Article 59. Even if Article 59 is not retracted, the suit article would be. But this is the point of limitation. यहाँ पर क्या था कि minor था, वो majority होने के बाद उसने suit नहीं file किया. Therefore, मेरा वो इस point पर था. This is not directly. Not, I am referring to another judgment. This is 2006 Orissa. यहाँ पर तो कोर्ट ने यहाँ तक कह दिया कि अगर कोर्ट का ऑर्डर भी है देन ऑल्सो इट इज अ नलिटी. पैरा नंबर 22 देखा जाए. May I place note? Law is well settled that a decree or a registered document which is otherwise ab initio void need not be set aside. Such decree.
ये para number कौन सा पढ़ेगा?
पैरा नंबर 22 में.
22 तो
22 of 2006 में.
हाँ 2006 it is something else. It is referring to 1968 judgment.
This is मतलब ये उसके बाद उड़ीसा पे जजमेंट है मतलब उसके बाद बताऊँ. I'm sorry I missed page number. I put a flag on it. It is flag number 6th flag. Para number 22.
Please.
The law is well settled that a decree or a registered document which is otherwise ab initio void need not be set aside. Such decree does not strip the right of the party who is the real owner and was not a signatory to the document in question or a party to the suit. It is not the law that merely because somebody has obtained a sale deed, he has got the title to the property as a vending, and his title has been declared so long as the deed has not been set aside by the competent court of law. If the deed is void at the threshold, no steps need to be taken to set aside. The vendor may not have title to the title to convey, and in such a case, the title deed conveys no title and it can be ignored, not worthy of paper written. Member judgment has replied in view of the proposition of law, the argument advanced by Mr. So and so. The learned appellant, the suit is not maintainable. Absence of prayer to set aside subsequent sale cannot be accepted. Therefore, if Lordship, I do not challenge that sale deed, which is document itself is a void ab initio. I am not required to challenge them. The fraud vitiates everything, every solved matter. And my lord, the third point, my lord. The third point, last one. Last one, that the appellate court, being a last fact-finding court, has not considered all the issues, and has swiftly my lord answered the issues against me, my lord. For which, my lord, this second last flag may kindly be taken. My lord, my valuable right has been snatched away. My lord, para number 9. May I please, my lord? After having heard the learned counsel of the parties and on perusal of the materials available, we have read the provision section 96, which provides the filing of an appeal from a decree of a court arising from the original jurisdiction of the court authorized to hear appeal from the decision of such court. It is also well settled that an appeal is a continuation of the proceedings of the original court. Ordinarily, in the first appeal, the appellate court jurisdiction involves a rehearing on the law as well as on facts as invoked by an aggrieved person. The first appeal is a valuable right of the appellant, and therein all the questions of fact and law are open to be considered by reappreciating the materials and evidence. Therefore, the first appellate court is required to address on all the issues and decide the appeal, assigning valid reasons either in support, against, or a reappraisal. The court of first appeal must record its finding dealing with all the issues, considering oral as well as documentary evidence led by the parties. But here in this case, none of the issues have been answered by the appellate court. And the last statement, the last flag, that is on the point, my lord, that my exhibit F, which is the deposition, has not been considered. My lord, this is section 92 of the Evidence Act, exclusion of oral evidence. Whenever there is a documentary evidence, oral evidence has to be excluded. My lord, all the sons and the wife of the defendant has said, my lord, my husband was acquainted with the Hindi handwriting and he is signed only in Hindi and not in Bengali. Therefore, what this says, when the documentary evidence is available, the oral testimony is not sufficient to rebut the presumption. Therefore, in my humble submission, my lord, the substantial questions of law which have been formulated.
It is submission with respect to which document?
My lord, this is with this particular judgment, my lord.
Yes.
This is with respect to
You
exhibit.
are which exhibit?
Exhibit 7, 8, 9.
Exhibit 7, 8, 9 is what?
My lord, these documents are, my lord, my lord. The deposition of law, my lord, is that
Deposition will not
it's not, my lord, it's a deposition which says that before the court of law, my lord, if someone swears an affidavit, my lord, it can be said it is not signed by the person. Before the court, my lord, when the lordship is acquitted, my lord, before the election matters, my lord, party come in the dock, my lord, and sign, put the execute that particular, in front of the honorable court, I have deposed, my lord. But then it can be said, denied that document, my lord, and that particular exhibit F, my lord, is marked as an exhibit without objection. And that has not been considered.
It is not their case that you never signed in Hindi or Bangla. It is their case that you also signed in Hindi and Bangla. The vendor used to sign. The vendor signed both in Hindi and Bangla.
No, it is the case. He never signed in Hindi.
He never signed in Hindi. He learned how to sign in Hindi. So many documents were exhibited showing his signature in Hindi. There are numerous documents which have been shown to have been signed in Hindi. It is not the only document.
Their cases I have learned subsequently. If it is so, then 1991 ka document.
Whose cases that you have learned subsequently?
Lydia may have learned.
The vendor had expired.
Yeah.
So he was not there for the court for cross-examination. No, document will not replace the vendor.
No, this is document exhibit F,
No.
which says, my lord, that the document was exhibit 1981. The suit is 2002. Therefore, my lord, he was acquainted with the Hindi, my lord, also. And my lord, the wife and the son, who is the witness to the deed, my lord, 10 in 11. Lordship permit, may I place the depositions also, my lord? Few lines, my lord.
We are not here to reappreciate the evidences.
My lord, here, my lord, it is required, my lord, that since he was the witness to the deed, my lord, and he has himself deposed that my father has never executed a deed.
Then how his signature is also forged? Has he said that
He denied his signature, my lord.
He has denied. So his signature is also forged.
Well, he says so.
You do not know. You have to say.
He
But
says
he
so.
says that my signature is forged on the deed.
He has, if my lord, someone has not executed, how can he say not he has executed, my lord?
He has, you see, his signature is also there as a witness. Has he said that somebody has forged my signature?
In the specific words there is not mentioned.
What specific for forgery? There has to be specific word. We cannot assume anything. For forgery, there has to be specific allegation of forgery. And DW 11, right?
BW 10 was the wife, when the widow, and 11 was the son. Lord, if lordship permit, वो इसमें स्पेसिफिक लिख रहा है कि वो सिर्फ हिंदी जानते तो और कुछ नहीं जानते. मेरे पिताजी हिंदी लिखना जानते थे, बंगला नहीं जानते थे. बंगला में दस्तखत कभी नहीं करते थे.
He was a witness to the deed on which the plaintiffs were claiming.
Yes.
He has not denied his signature on the deed. Now he has explained how his signature was obtained on the deed.
No, neither it was cross-examined also.
Need not be. You have to say that your signature is forged. You are a witness to a deed.
No, it has not been said so.
So,
खाली वो इतना ही कह रहे हैं, ये आवाज जमीन के मूल्य का पूरा भुगतान लेकर रजिस्ट्री कहे, पाजरस जमीन पर रजिस्ट्री दलील नहीं दिया.
ये DW 10, right?
Yes, Surji there is.
She's the wife of
Wife of defendant number 2.
defendant number 2. ठीक. चलो, और कुछ बोलना है?
Lord, my only last submission, Lord, the plaintiff has not proved his case. Therefore, he has to stand on his own legs, cannot take the weaknesses of the defendant, Lord. And therefore, the entire burden was upon them to cross-examine and prove, my Lord, that the deed was, subsequent deed was what was forged, fabricated.
हाँ, बोलिए.
Can I do it tomorrow? It's already 4:30. It would be. I'll take only
10:30 बजे आ जाएंगे. Continue to listen.
2:15 रखा जाने
दो
लगा.
15 नहीं
My Lord, it
रखना.
will
ऐसा
be 2:15,
continue
my Lord, 10, my Lord, there is
नहीं
one
हो
more.
सकता, ऐसे नहीं हो सकता. आप चाहे तो अभी कंटिन्यू करके 6 बजे तक कंप्लीट कर सकते हैं.
But I have a difficulty.
ऐसा नहीं हो सकता. आई ऑल्सो हैव डिफिकल्टी. फाइल पढ़ना पड़ता है सेकंड अपील का.
Yes.
हाँ तो फिर आपके अनुसार डेट टाइम नहीं हो सकता है ना. सेकंड अपील का फाइल आपसे ज़्यादा पढ़ना पड़ता है क्योंकि आप लोग कुछ कुछ पढ़ते हैं, कुछ कुछ नहीं भी पढ़ते. यस.
मतलब बस कुछ ही फाइल
We have more responsibility in second appeal because the questions of law are being framed by the court. The court has a responsibility in connection with question of law and the answers to it. 10:30 बजे आ जाइए सुबह।
12:30 कम से कम 12:30।
नहीं ऐसा नहीं हो सकता ना, क्योंकि देखिए आई टेल यू वन थिंग, दूसरा फाइल खुलने के बाद मेरा माइंड डाइवर्ट होता है, आपको मेरे माइंड की भी चिंता करनी चाहिए, ऐसे नहीं हो सकता।
Not with due respect, my lord, at 2:15.
No,
There's
no,
one
sir.
case as serial number 1, my lord. Therefore, my lord, I'm saying.
Parthered matter has to be given precedence. ये क्या प्रोसीजर हम आपको बताएंगे? Parthered matter has to be given precedence, even precedence to the judge, to a matter placed before the honorable chief justice. That is the law. That is the procedure of our court. बहुत दिनों से इतना वेल एस्टैब्लिश प्रोसीजर है कि इसके बारे में हम कुछ बोल ही नहीं सकते। अगर आपको नहीं पता है तो आप इसको जान लीजिए। Parthered matter, maybe before a single judge, has to be given preference with respect to even division bench
With
matters.
due respect, there's one more parthered in court number 24, my lord.
हम नहीं जानते।
It's serial number 1. It's
और आपको ये भी बता देते हैं जो सब्सिक्वेंट पार्टेड होता है वही सबसे पहले पार्टेड टेकअप होता है, ये भी आपको बताएं? नहीं हम कल इस तरह से नहीं कर सकते, जस्ट कंटिन्यूस
only requesting for
नहीं करना है तो आप लोग मत करिए, हम एडजर्न कर देंगे 3 साल 5 साल 10 साल के लिए, कोई प्रॉब्लम नहीं है।
नहीं, my lord, इतना short notice
जॉइंट
में
प्रेयर
रहेगी।
करिए 10 साल के लिए एडजर्नमेंट, आई
Yes,
पास
I'll be
जुडिशियल
there.
ऑर्डर दैट ऑन जॉइंट प्रेयर द मैटर इज एडजर्न फॉर 10 years। ऐसा नहीं, बहुत मुश्किल से देखिए ये सारे केसेस हमको भी टाइम लगता है समझने में। आई हैव टू आल्सो स्विच माय माइंड टू सिविल मैटर्स एंड एवरी डे रीड जजमेंट्स, इवन दोज जजमेंट्स व्हिच यू आर नॉट साइटिंग, वी हैव टू रीड, वी आर बाउंड टू रीड इट। ये हमारी ड्यूटी है और इसको हम करेंगे, आप असिस्ट करिए चाहे मत करिए, इससे कोई मतलब नहीं है। इसीलिए कल 10:30 बजे आएंगे और कल हम लिखाएंगे भी इसको। essay number 61 of 2017. The learned counsel for the appellant has submitted that the deed, the original sale deed which was executed in favor of the vendor, the executive, the original sale deed which was executed by Rajmani Mandal, which was executed in favor of Rajmani Mandal, was also exhibited by the defendant number 1 as Exhibit D. This itself is sufficient to show that defendant number 2 had executed the deed, the sale deed, in favor of the defendant number 1 and not in favor of defendant number 2. For this, he has relied upon the judgment passed by Honorable Delhi High Court, reported in bracket 2012 bracket close DLT 525. He has further submitted that the document of title as claimed by the plaintiff was a void document, and void ab initio document need not be challenged. He has relied upon the judgment passed by Honorable Supreme Court, reported in AIR 2006 SC 3608, and also judgment passed by Honorable Odisha High Court, reported in AIR 2006 Odisha 21. He has further submitted that the first appellate court was required to address all the issues, and the first appellate court is the final court of fact and law. For this, he has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2022 within bracket 7 SCC 678. The learned counsel has submitted that the exhibits F has not been properly considered. He has also submitted that DW11 was the witness to the sale deed executed in favor, said to have been executed in favor of the plaintiff, and he has deposed before the court and has denied the execution of the sale deed by his father. The learned counsel submits that the defendant number 2 died during the pendency, and ultimately his son and wife deposed. The wife deposed as DW10. and has clearly stated that the defendant number 2 never used to sign in Bangla, in Hindi.
He never used to sign in Bangla.
He never used to sign in Bangla, but he used to sign in Hindi. That's all.
If Lordship considers that fraud has been fraud vitiates every solemn act.
The learned counsel has submitted that the fraud vitiates every solemn act, and the deed in favor of the plaintiff was a deed obtained by fraud, and therefore the same was not required to be specifically challenged by the defendant. The learned courts have not considered the fact that the plaintiff failed to prove his case and has wrongly retrieved the support.
If Lordship considers, although there is no question, that plaintiff has not been examined his case, therefore adverse influence has to be drawn. If Lordship pleases, it can be.
The learned counsel has also submitted that the plaintiff was not examined in the case,
Therefore, adverse influence has to be
and
drawn.
therefore adverse influence has to be drawn, which has, and the courts have failed to consider this aspect.
Shall I provide the authority also?
Yes. After
Okay.
pose this case for further argument tomorrow to be taken up at 10.
Last one would apply to him also because she was also not examined. So
Who?
once he is doing it, obviously it would affect him
Who was
also.
not examined?
Rajamani Mandal.
Rajam, वो तो मर ही गया ना.
Principal defendant.
She was also not examined.
None was
Never,
so-
she never.
आपका last
So it
submission
cuts
लिखे कि
both
ना
sides.
लिखे?
ठीक है मैडम, क्योंकि मैडम मेरा केस तो कि इनका केस तो पहले इनका प्लेन
ठीक
डिवोर्स
है,
होगा तो
ठीक
मेरा
है.
कहता रहेगा.
That I'll answer.
अच्छा ये जजमेंट से लो.
For judgment item 1, WPL 3402 of 2013.
This writ petition is dismissed. Second appeal.
Item 2 is second appeal 416 of 2016.
The substantial question of law is answered in favor of the appellant. The appeal stands alone. आपको सुनाई दिया? समझ आई?
I was praying for adjournment in item number 6.
एडजमेंट हो ही गया ऑटोमेटिक.
नहीं, आपको चाहिए लंबा आफ्टर इसको रख दिया जाए क्योंकि मेरा क्लाइंट इज इन ऑस्ट्रेलिया. ही विल बी कमिंग एंड ऑफ दिस मंथ.
किस लिए आएंगे?
माय क्लाइंट
हाँ तो किस लिए आएंगे?
he has gone to Australia to look after his son who is sick there.
Very well.
Madam, hear me. They will be executing these joint these dates. Appellant number 1 and respondent number appellant number 2 and defendant number 2 for the same with the bank ICICI, which was
I don't know.
earlier.
अभी देखिए रिकॉर्ड भी नहीं मेरे
नहीं
पास.
earlier executed.
भाई आप कहीं नहीं ना जा रहे हैं. जब भी नेक्स्ट वीक में आएगा तब आप अपना
हम बोल रहे हैं कि उसको सिर्फ एडजॉर्न कर दिया जाए आफ्टर होली, तब तक वो
नहीं ऐसे नहीं.
हम लोग कर देंगे.
बिना फाइल देखे हम कोई केस एडजॉर्न नहीं करते.